was enough to persuade a court that she would have committed a crime in the future, therefore she's guilty of an offense, an unknown crime. So someone in your office thought that there was a good case here, including of state capture.
Yeah. No, I don't agree with that. Definitely, it shows, if you read this as an independent person who comes after the fact, it tells you immediately there was a lot of investigation still outstanding. And you couldn't have arrested, go through the processes, bail application and stuff, and then only do the investigations after. Especially commissioners that we're dealing with a high-profile case, or at least a case that involves the high-ranking officials in government. You don't just arrest people, put them into the court system, only to postpone for investigations. And these cases, we prepare them over a period of time. It's like in the lower courts where we receive decision dockets. I must prepare it in such a way that there's at least a prima facie case. When I put it on the court roll, the one thing that I must do is to postpone to seek a trial date. If the defense says give us copies of the docket, to postpone for disclosure, but not to put a case on the court roll, which we have worked on. This case, I understand, started in December or November of 2024, and by June of 2025, they put it on the roll. For that 6 months, these issues ought to have been covered. You don't put it on the roll only to postpone it for investigation.
Is it fair to say that your memorandum, the questions that you're raising, suggests that your view at this point was that you don't even have a prima facie case yet, at this point?
Clearly there isn't a prima facie case. When I asked them, for the first question, why are the accused charged with corruption? Who corrupted who? I can't see it. There's no corruption. Who corrupted who? Yeah. So there's no prima facie case, not even on the lowest standard of corruption. There isn't.
Did the ID engage you about this memorandum where you're saying we don't even seem to have a prima facie case? Did she come back to you and tell you, no, you're wrong, we do, and these are the reasons?
But now, Commissioner, I was never engaged by the ID on this memo. At least the investigating officers tried to respond to some of my questions.
Yes.
But what they did basically was just to recite what the Act says, and not to deal with the questions.
Thank you.
You were actually playing devil's advocate because this is engagement between you and your colleagues. It wasn't you forming a conclusion one way or the other. You were simply saying to them, let's cover all the tracks. Let's make sure we've investigated this, we've investigated that. And I think all your questions, to be honest, are fair questions to ask if you are given a docket for the first time and you look at it. And then you say something very important somewhere in your statement, because you say even the arrest warrant should not have been issued on these facts.
Indeed, Commissioners, on these facts, there was no case. It couldn't have been. And maybe on the issue of the warrant, Commissioner Kumalo, when I first read the docket, because the statement applying for the warrant forms part of the docket, I remember having a discussion with Advocate Lachwa and asking her how did the magistrate authorize this? And I remember she told me on the first occasion when Brian Barayashi went to court to ask for a warrant, the magistrate turned him away, saying a statement.
So the one that was issued was the second one?
It was the second one to try.
There was one where the magistrate refused to grant the warrant.
There's one where, yeah, there must be one where the magistrate refused to issue a warrant because the magistrate was not convinced that there was a case. The magistrate who sits and does this, so the magistrate sent him back, and he went and compiled another one, went back, succeeded with the second one. But still, when I looked at the second one,
But why do you say it looks more like heads of argument than an affidavit?
it's because when I read it, it's like a person is trying to, it's like an argument. He's trying to justify why we want to have a warrant issued. But if you have
Chair said it has more conclusions than facts. That's how Chair put it. Is
which
that
I
also
agree
your
with.
view?
Which I agree with, commissioners. If you have a case, you have a case. You're not going to struggle with drafting an affidavit up to apply for a warrant. And as a prosecutor, you're not going to struggle to draft a charge sheet. If you have a case, you have a case. And I always say to the juniors that come in as part of training, I say, you will see, when you struggle to draft your charge sheet, you must know that there's something wrong with your evidence. If a person stole an item at OK on the 4th of August 2026, your charge sheet reads theft on such and such a day at or near OK Central, this person stole this item, you even describe it worth so much. But if you're struggling to put it into words, what did the person steal, where, when, then it tells you you have a problem, which is what I was encountering as I was writing this email. Who corrupted who, how? There was no evidence to support all that.
After your recusal, you may not necessarily have details, but I'm interested to know whether your questions, I know there was a response, but whether the substance of the issues that you were raising, to your knowledge as we sit here now, was the substance of your questions ever answered cogently?
Chair, they were not. And maybe that is why I wrote a second, or at least in the third trial preparation note. They were not. And I was saying to the evidence leaders as we were preparing this affidavit, and I said, well, I recused myself at least a month and a half after getting it, but if I had gone on and those questions were not answered, I would have withdrawn this case. I would not have prosecuted this case on the basis of the evidence available at the time, unless if all of these questions were answered. I would not have proved a case in any event, even if I went on trial, at least with the available evidence. So I asked questions and I made a follow-up, and I think I sent a third trial note where I got the response was confirmation of Ms. Mukwele's qualifications and one or two other things, but by and large, my questions remained unanswered.
Yes. I'll make a comment that I've made repeatedly during the testimony of the IDEC witnesses. We are not asking these questions so as to pronounce on whether the generals or the officers are guilty or not. But we are asking questions that may touch on whether there was a case at all, because for us at issue is whether charging the generals at all was improper. So questions of whether there was a case to start off with may be relevant to that question, which is relevant to what we are about. Now, I thought I should just again, for those who may be asking themselves, but are they a court that's going to answer the question of guilt or not? So I thought I should just again repeat that comment. It's probably for the third time that I'm making that comment. Let me ask another question. When you sent your email with your several queries on the 16th of August 2025, just before you went to watch Pirates and Sundowns, you also copied the Advocate Johnson's PA, or you sent her separately. And your cover email to which you attach the queries, you say FYI, which means for your information. Here's what I want to understand. On internal IDEC processes, what would you have what would your intention have been? Would this have been for the information of the PA only, Ms. Sikukune? Or did you believe that she would not hog this, but that she would forward it to her boss, Advocate Johnson? And if your response is the latter, why did you not say this is for the information of Advocate Johnson? Then that way there would be no question that this would end at Advocate Johnson's desk.
Thanks.